Okay. Thank you all for joining us for Understanding Intellectual Property workshop. Joining us today, we have Michael Mosher, Director, Commercialization, Office of Economic Development. He's going to discuss the fundamentals of intellectual property, copyrights, patents, trademarks, and trade secrets, and how they apply within the academic and professional context. So I will go ahead and hand it over to him.
Yeah, thanks so much. Hi, everyone. So just to begin with, I'm going to go ahead and pop a question into the chat, but I do want to just say, feel free. I'd love for participation. If you have any questions, feel free to just, shoot something into the chat and I'll try and take a look and get back to you as soon as I can, or you're welcome to follow up with me afterwards. So let me just go ahead and do that. We'll come back to this in a little bit when we get to the right section. But for now, if you want to go ahead and answer the question, great. If you want to wait, that's fine too. Okay. But again, my name is Michael Mosher. I'm Director of Technology Commercialization. I work in the Office of Economic Development. And so I've been here for about 2.5 years, but working in academic tech transfer for 10 plus years. My background is in intellectual property law. And I'll get to that. But just for today, we're talking about intellectual property. I do want to talk, maybe just start off talking about just what is intellectual property in the academic setting, because with everything that's going on, I think we have a really unique opportunity. And I would love for, if anybody's ever interested in technology transfer, intellectual property at universities, I would love to talk with you. We're always looking for more people that are interested in it. In fact, I'm in the process of probably hiring a couple grad assistants. And so, again, feel free to shoot me an email if this is something that's of interest to you. So I do want to take a few minutes just to talk about, what is intellectual property in the context of academia and universities and how it works, before getting into the main part of the discussion about patents and copyrights and trademarks and things like that. So with that, let me go ahead and try to share my screen. All right. Okay. Okay, so again, my background's in intellectual property law. Intellectual property and patent law requires a science background, requires a science degree of some sort, or a sufficient number of classes in order to take the patent bar. It's a little bit of a different type of law. Tech transfer, as we say in our industry, is a mix of science, business, and law. So that's sort of how someone like me ends up working for a university in academic tech transfer. But background, again, is all the research and inventions that are invented at the university. They find their way to my desk and I review them. I work with outside counsel. We file patent applications, and then we work on a whole lot of agreements, contracts. And so for anybody who needs some help with contracts or agreements, I'm happy to. Again, I can really only help faculty, staff, employees. But I'm always happy to just have a discussion with you if you are, say a non-employee student or member of the community. So again, just starting off with why tech transfer, why intellectual property is important to universities. Okay, there's just so many different things that we do here at UNLV. It's not just patents, it's not just copyrights, but just we're trying to create these life-changing products, services. What we say is we try and push things out of the university into the public domain. And in the Economic Development Office, we actually also try and pull industry to the university to create these collaborations. But again, just thinking about on everything that we do, all the hundreds of millions of dollars of research funding that comes into the university, we're trying to move everything out into the public domain. And industry and our industry collaborators are very interested in the intellectual property side of things. So again, this is part of what we do in the Economic Development Office. Things are very much changing right now, which I'll talk just a little bit about. But again, I'll send these slides out to you all. But in a nutshell, I mean, this is tech transfer, right? This is the idea of tech transfer, of moving things out into the public. It's not just disclosures and patents, but we're also focused on startup companies. We license technology to industry, and that's why contracts are so important. We do try to generate as much revenue as possible, but that's not our main metric. For every probably $100 million, or let's just say for every $1 million of research funding, maybe you'll get a disclosure out of that. And then maybe, some of those disclosures will turn into patents, and some of those patents will turn into, startup companies or will end up with licenses. But, we are we're just always trying to maximize the return on investment. And that's, it's been a big topic of discussion these days. How do universities work? How does research funding work? And for us, it's all about maximizing investment, return on the investment. Okay. So again, just kind of more things. The circle, this tech transfer life cycle is important because it's not, again, not just about patents. Our office, we take whatever is developed in the research and development, it goes through invention and evaluation, and the end goal is to inject, create those collaborations that inject more money into research and development. So if we start out with, say, again, $10 million of federal funding, well, we're hoping to transform that into a certain amount of, investment from industry, from our partners in the industry. Everything that I do, and again, we're going to get into the intellectual property part of this, but this is a crucial part of how things work at academia and universities. So everything that we do started in the 1980s with something called the Bayh-Dole Act. And again, it's important these days because right now we have an administration that's considering whether or not the Bayh-Dole Act is still a good thing, whether or not there are changes that need to be made to it. But we have a long history now, about 45 years since the Bayh-Dole Act was enacted. And what that does is it gave universities then the right to commercialize their technologies. Okay, before that, really the government controlled all the intellectual property. So when the Bayh-Dole Act was invented or was put into law, all of a sudden universities could do things with their intellectual property. So there's a patent or an invention. Now we could file patents, we could own patents, we could license patents, and we could, we had when all this happened in the 80s, we had just lots and lots of companies. So big pharmaceutical companies, they all rushed over to universities to see, what do they have? What can we license? What can we get out of universities? And over time, that's changed. The industry has gotten better at basic research. Universities have gotten better at more advanced research. But again, everything that we do these days is based on the Bayh-Dole Act. And so as a part of that, we're expected to file patents. We're expected to, give preference to small businesses and to U.S. businesses and businesses that are in the state. The government does retain certain rights to the inventions. So, if anything really world-changing was invented through government funding, federal funding, I mean, the government could, in theory, come back and ask for some of that back or take over it potentially. Only under very certain circumstances. And in general, it hasn't happened. Okay. But, again, figured it was worth talking about just with everything that's going on. This is a lot of what we deal with. And this is really how intellectual property works at universities. Okay. And so again, in tech transfer, these are the things that I deal with every day. I mean, we have inventions that are coming in and we're trying to get things moving forward. Industry typically wants inventions and patents and products that are very far along. There's something called a technology readiness level. So they want some technology readiness level at the top of that scale, 7, 8, 9. Universities were really good at doing the technology readiness level at the very low end of 1, 2, and 3. And so, when you hear the terms like valley of death or, gap funding or things like that, we're trying to move intellectual property, patents, the inventions into that middle ground where industry will be more interested in, again, taking a license to it. Or again, maybe we're starting up a company and that company is trying to develop prototypes. They're doing proof of concept. They're trying to do scale up and move that along to, again, maybe a 5 or a 6 or a 7, where industry will be more interested in taking a license to it and taking it to the next stage. Okay. So again, I mean, if this is just generally something that's of interest to you, please feel free to reach out to me. Again, we are going to be hiring some grad assistants. We're always looking for interns, things like that. So whether that's on the business side of things, whether that's on the science side of things, and you're really interested in again, how the science works and moving the science along from just basic research to a little bit further to prototype to proof of concept. There's work, there's things to be done in our office. Or again, maybe that's on the law side of things. If anybody is interested in, say, patent law, intellectual property law, this is a really interesting mix. That's my plug for tech transfer. It's a really interesting mix of science, business, and law. And most people only have 1 or 2 of those 3. And that you can get into this field. It's a whole field. There's there's a person just like me, a tech transfer director in every one of the R1 institutions and probably a lot of the R2 institutions. So, so let's just say the top 200 universities in the country have somebody like me. They don't all have economic development offices, and we're not all set up and structured the same way, but they all have somebody like me that's trying to push technologies out into the public domain. Okay, so these are, again, I do want to move things along, but these are all things that we do. There's a lot. We have a good sized team. Again, I mean, even for some of you that know, Harry Reid Technology or the research park over in Spring Valley, that is where our economic development office is located. If you ever want to come by, it's a really neat place. I mean, we have sample hotel rooms with disposable sheets. We have a lot of hospitality type stuff, an esports gaming arena. There's a podcasting center. I mean, there's really a lot of neat stuff over it. That's a Blackfire Innovation Building at the research park. But again, we're involved in so many different things, including things like the film bill. While it was still up and running, we were trying to build a film production studio out there in the research park, and there's a pediatric hospital that we're hoping to have a groundbreaking next year. So all things that our office is involved with. And again, hopefully this background is helpful, but I want you to understand how all of this, works at a university, how it relates to the work that graduate students are doing. What I say to the researchers is, what do you want to do beyond publish? And so that's a question for every grad student. If you just want to publish and you're not really excited about the work that you're doing, that's fine. But if you're excited about it, you want to do something more than just publish research, I would recommend you come talk to me. There's something that we can do. So again, it's not just a matter of if it's patentable. We're looking for markets. We're looking for partners. We're involved with starting a new company. A small business development center is run out of the Office of Economic Development. So their office and a lot of their workers are just work over there in the Spring Valley office with us. And then we can try and match companies. We can help look for funding. We're all about establishing relationships with industry. Okay. If you are interested at any point, the university has a technology publisher. If you just search available technologies for licensing, you can see a lot of what the university does. We also have a university dashboard, which is some of our, the licensed, marketed technologies that we have for the university. And again, important for graduate students and employees, the revenue share at UNLV is really better than I've seen anywhere else. There probably are potentially some other, maybe one or two or three other universities that have something similar. But the revenue sharing after expenses. So if the university brings in $1 million for some sort of an invention, okay, 60% of that, $600,000 go directly to the inventors or creators. Okay, so the majority of any income from any kind of university invention goes to the inventors and creators. Now that's going to be split up, and that is after things like patent costs. But the average across the United States is probably closer to, say, 30% instead of 60%. So very important. If you find yourself in the situation where you think you've invented something, a lot of people are concerned about, should I disclose to the university? Well, you absolutely should, because we do a lot on our end to help, patent expenses, contracts. There's a lot that we do to help move that technology out into the public domain. Yeah, again, more of the same, just types of things that we do: job creation, business creation, patents, revenue. Okay, so this is an important thing for everybody. There's a couple of policies. I don't want to get too much into the weeds on this, but just keep in mind that if there is federal, state, or university funding that's funding your research, then the policy is probably triggered, and the university likely has some rights in that. Okay, so if you're personnel, if you're using significant use of university resources or state money or federal money, chances are the university probably has rights to the invention. If you think about any kind of a company is just going to own it outright. But again, at the university, 60% of that will actually, any income that's generated will actually go back to the inventors. There was a question in the chat: what happens when you graduate? So anything invented under this policy while you're at UNLV stays with you. So if you go to another institution, if you go just to wherever you go, this will follow you. So any income that comes into the university, it flows out, and we would find you, we'd track you down, and we'd, make sure that you're involved in the process. Patents take several years potentially. So, we do want our inventors, and of course people move around a lot. So we want to include everybody. If you do invent something, and you move somewhere, I would really recommend you let me know or someone from our office know. It's innovation@unlv.edu. Just keep us updated with your contact information, especially if something becomes profitable and money starts coming in. I mean, it's not like we're going to give it away if you don't, if we can't contact you. That'll be just put aside. But yeah, it's good so that you can be a part of those discussions on the patent side of things, on the licensing side of things, on the marketing side of things, and then if there is any income generated, yes, it stays under our policy. So if you go from one institution to the next, and that's how it always works, is it just whatever it was invented and disclosed, and whoever it was disclosed to, it goes under their policy. Now, of course, it can get messy. Let's say you invent something here and you want to keep working on it at a different university. Great. Usually that tech transfer office will call our tech transfer office and we'll just try and draw some lines in the sand so that you can keep doing what you want to do. Again, having invention disclosures does help. So just to make sure that everybody knows, this was done at UNLV, this was done elsewhere, because they're going to all have different distribution policies and different procedures just in general. So yes, it does follow you if you invent something here. Okay. Um, there's a lot of misconceptions about this. Honestly, even I know this is an online class, even if you Google it, you might not get the right answer because there are a lot of misconceptions about how patents work. So, just the basics, right? This is a Congress, a federal law thing. Even the patent bar itself is a federal bar exam. So, to practice law in general, you need to be licensed to practice in each state because the states have their own rules. Well, with patents, that comes from the Constitution and the federal government. So the patent bar is a federal bar exam, which means you only have to take one for the whole country. Okay. Um, in general, anything, as the saying goes, as part of case law, anything made by man under the sun, right? So basically anything is patentable. There are some exceptions. Okay. But just really anything that's developed by man, by a person, is patentable. And of course, now we're getting into things like AI, and we've even had some cases on, can animals, can even primates, invent things or have copyrights or things like that. And generally, the answer is no. We can't have AI because this is, it really is limited to human beings. Okay. So let me check the chat. So we said, patent documents an invention idea for the purpose of owning the idea and getting paid for licensing. Okay. So a patent is just the right to exclude. So this is a little bit because you hear the words say limited monopoly, right? A patent gives you a limited monopoly. It's sort of true, but it's sort of not true, because at the end of the day, if you get a patent, you have no right to use it. Okay, it is not an affirmative right. So, for example, if you have a patent on a chair with 5 legs, or we'll just use a generic example. Your patent involves three pieces, A, B, and C. You get a patent for A, B, and C. Great. So if anybody else then comes along later and they are, making, using, offering for sale, selling in the United States, and that is important, or importing, and importing is certainly important as well, then you can stop them. You can sue and you can stop them and you could potentially get some damages. Okay. If they are doing A, B, and C. So if they're doing A, B, C, and D, well, again, you're actually okay, right? Because they're still doing A, B, and C together. Doesn't matter if they add things down. So anything downstream, you can stop them from doing A, B, and C. Now, if they make a change and they're not doing C anymore and they do A, B, D or A, B, that's it. You don't have any right to stop them. It really matters what your claims say. Now, why we say it's a right to exclude and not an affirmative right? Well, the patent office we'll just say they're not concerned. I think it's fair to say they're not concerned at all about whether or not you can practice your patent. Okay, so if you get a patent, again, you have no right to actually use that patent. There is no freedom to practice it. You don't get any benefits from just saying, oh, I got a patent on it and I'm going to use it. It doesn't work like that. Only get a right to sue people. So if someone else comes along then, because again, the patent office didn't look for it, they didn't care, they just looked at the patentability, which I'll get to in a second. But if somebody else comes along and they have a patent on A, guess what? They're suing it. And nobody did anything wrong, but you don't have a right. Just because you have a patent, you don't have a right to use that patent. So again, somebody has a patent on A, or somebody has a patent on B, or somebody has a patent on C, or A and B together, or A and C together, or B and C together. Again, the patent office is not concerned with that. So, to the extent that you ever file a patent, get a patent, just keep that in mind. And especially if you want to start up your own business, if it's your own patent and you're working as an individual, before spending the tens of thousands of dollars that it takes often to get a patent, you might consider whether or not you're actually free to practice it. If you actually got the patent, would you be free to practice it? Freedom to practice search is something that people do. Um, it's not the easiest thing. They are expensive. It's a lot more time consuming because if you're trying to make sure that you're okay, you're doing your due diligence, you have to look for everybody that might have a patent for just one of those pieces. Okay, and it gets more complicated the more pieces of the patent that you have. So this comes up all the time with graduate students, with graduate researchers, assistants. Are you an inventor? So if you're doing work in your lab and you have a faculty advisor, they're directing you what to do. You might think that you even feel like you made a big discovery. Okay. Invention involves three stages, and by far, the first one is the most important. So conception. Who came up with the idea? Okay. You have to have taken part in general, and I'll explain that, in all three of these in order to be an inventor. So if all you did was follow the instructions, somebody gave you a recipe and you just followed the recipe, and even if nobody had ever actually done that recipe or created that recipe, and you're the one that actually did it, you're not an inventor unless you contributed to the conception of that recipe, unless you helped, unless there were some brainstorming sessions and creating, 50%. Doesn't have to be 80%, doesn't have to be 20%, but you have to have contributed to at least one claim in a patent. And I'm getting a note just so you know, my internet connection is unstable because, of course, I'm in a university building. So why not? Okay. Um, so if you didn't contribute to the conception, you very well may not be an inventor, and this does happen. So if we get a disclosure from a faculty member and they say they're the only inventor, well, that's usually the case, that because they're the only ones that conceived of the invention. And yes, they might have given grad students some orders, some issues, they're the ones doing the actual work. They might even understand it better. A lot of the times that I see the grad students, I mean, they're the ones that really understand the science. They still might not be an inventor. And when this happens at a university setting, we play it safe. We get an inventorship opinion. The law firm interviews everybody. They all get contribution statements. And then we compare those to the claim. And if it looks like there's any contribution to any part of the claims, then they're an inventor. It's going to be that simple. But it is something to consider. If you're working in a lab, try to make sure you're a part of those brainstorming sessions. If you're recommending improvements, if there's just something that you do that's not just following the orders. Okay, if you're just following orders and just doing the work in the lab, that's generally not enough to be an inventor. Now, in terms of what is an invention and what is patentable, there's a couple of different considerations. One is it new and novel? Is it something that is just nobody else has done before? Okay, and that's every piece of the invention. So again, if nobody has done a combination of A, B, and C, it's still novel. Okay, you can still get a patent on it. It just doesn't mean that you can't get sued. Software, yes. That is a great question. Let me come back to that in just a minute because there are software patents. If you ever do end up wanting a software patent, you're going to need a software patent attorney. Don't just get somebody who is a generalist. But yes, there are software patents. But let me come right back to that. Okay. So the first step is it novel? Again, not just each single piece, but is the combination novel? It doesn't mean that you won't get sued, but that's the first piece. Is the combination of your pieces novel? And the second piece, and usually what happens at the patent office, okay, they will say, and they will go through this assessment. They will say, okay, claims 1 through 5 are novel, claims 6 through 10 aren't novel. And then they'll go on to the next step and say, okay, is it also obvious or non-obvious? Okay, and so you can read this in 30 USC 102 and 103. Obviousness is a much more difficult concept. And it's obvious to a person of ordinary skill in the art. Okay, that will come up if you ever see it, if you ever study, if you ever care about someone, it has to be obvious to someone of ordinary skill in the art. So not an expert,